Hi there, this is Jonathan Ginsberg. I'm a bankruptcy and student loan attorney based out of Atlanta, Georgia. And I get a lot of questions, not surprisingly, about student loans and bankruptcy and whether or not there is any hope that a student loan can be discharged or otherwise dealt with in a bankruptcy. And the answer to that question is it depends. And I would also tell you that I'm recording this in March of 2018. That answer has gotten a lot more complicated more recently because I think for a long time the assumption was that student loans were generally not dischargeable. But I think now there is a shift going on, and it's a slow shift, but I think we're starting to see some movement on the part of bankruptcy judges to either A, recognize different theories of discharge rather. The second thing would be that the bankruptcy courts are recognizing that we have a real problem in this country in that there are a lot of people, a lot of young people, 20s and 30s, who graduated school without really much hope of ever paying their student loan back. And the reason for that, and if you're living this, you certainly know this, is when you're 17 or 18 years old and you want to go to school, and somebody hands you a stack of papers and says, sign here, you can go to this great private school, you are not thinking about what's going to happen 15 years down the line, how much money you're going to be earning, and whether you're going to be able to pay that student loan debt back. And you're also not looking at the school saying, are they providing me any kind of value? Because from the school's standpoint, there's a lot of free money out there. The government, the Department of Education, issues all student loan money at this point. It used to be they guaranteed it, now they actually issue it. So if you're a school, you know that you have a rock-solid source of money for tuition, so you can charge whatever you want because you got a bunch of people that are signing up for these loans that don't really understand the finances aspect of it. There's really no accountability in the part of the schools to provide a valued education. I mean, you look at some of the majors being offered, and there's really no jobs that are associated with these majors, and so people come out of school owing $80, $100, $200,000 of student loan debt, and they get a job making $25,000 or $30,000 a year. So the math doesn't really add up. So, not that the bankruptcy judges say that this is how they solve the problem, but I think that we're seeing now a shift away from the hands-off approach that maybe bankruptcy judges were giving this question even just a few years ago. So I'm going to answer this question over the course of several videos, but for this one, let's start with the basics, and that is Code Section 523. This is the Bankruptcy Code that basically talks about student loan. And if you look at basically an exception to discharge basically means that this is a debt that is non-dischargeable in bankruptcy. So you'll see there are certain, for example, tax debts and money obtained by fraud or false pretenses. That's one. And then you've got domestic support obligations, things like that. Then we have Code Section 523A8, which is right here. And that is basically, this deals with student loans that unless accepting such debt from discharge would impose an undue hardship on the debtor and the debtor's dependents for an educational benefit overpayment. We'll go into those details later, but bottom line is that the way I'm going to read this is if you have a government student loan, not private student loan. This is for government student loans, and private loans can fall under this, but for right now let's just talk about government student loans, Department of Education issued loans. Would discharge or denial of discharge impose an undue hardship on you? And so the question obviously is, what does it mean to have an undue hardship? And when this came out, this I think came out in the late 1980s, a version of this, it's been changed a couple of times, but the undue hardship came out in the late 1980s. Several courts considered this, and then the Second Circuit Court of Appeals kind of made the seminal decision here in a case called Brunner versus New York State Higher Education Services Corporation. And the Brunner decision, which was issued in late 1987, basically set out a three-part test to determine what does it mean to have undue hardship. And part one of this test is that would the debtor be able to maintain a minimal standard of living for himself and dependents? Two, is it likely that the circumstances that this situation is going to extend for a significant portion of the repayment period for student loans? And three, has the debtor made a good faith effort to repay the loan? So basically what this means is that if you would have the money, have the income to lead a life where you had a minimal standard of living, then and that situation is likely to continue, you are not going to be able to discharge student loans from bankruptcy. In other words, you cannot discharge the debt, you have to pay it. And obviously, a minimal standard of living suggests a person living in an apartment with a card table and a couple of chairs eating ramen noodles. So it really is a very, very strict standard, and that's the way courts have interpreted it for the most part, that if you go into court and say, I have undue hardship and I need to have these loans discharged, the court's going to basically say, do you have any capacity at all to support yourself? And if you do, sorry, you have to pay the student loans back. And generally speaking, and I'm in the 11th Circuit, which is Georgia and Florida and basically in the South here, that unless you have a medical disability, you're not going to be able to discharge your debt. So if you're in your deathbed, you can come in and say, I'm not going to be able to work at all, or I don't have the capacity to work more than 15 hours a week or something like that. Maybe you can get the loans discharged. But generally speaking, the courts have been very, very tough about this type of discharging student loan debt. Well, that's still the case, and I think it's still very difficult, but I think what we're seeing is some bankruptcy judges are looking at this a little more broadly. What they're doing is they're saying in some cases, we're not going to let you discharge all the student loan debt, we're going to let you discharge some of it. So if you walk in there with $80,000 of debt, basically of Department of Education debt, some judges are saying, well, we're going to let you discharge 30,000 or 40,000 of it. You got to pay back the other 40,000. We're going to let you discharge half of it, or a third of it, or 2/3 of it. So that's one thing that's going on. And the second thing is that I think some judges are looking at this saying, a minimal standard of living is not bread and water. That you can have a little bit higher standard of living and still discharge some or all of the debt. So I do think that there is a little bit more willingness on part of some judges to find that some student loan debt, some federal student loan debt, is in fact dischargeable in bankruptcy. Now, I will tell you that the problem that you run into in any kind of litigation like this is the cost of litigation, because if you want to litigate the question of undue hardship, that you don't have enough money to lead a minimal standard of living, but you got to pay a lawyer $5,000 or $10,000 to go to court and litigate it, because you're going to have to litigate this, that's a problem. A lot of people don't have that kind of money. So when I talk to clients that say, well, I just can't afford to pay these student loans, and I want to try to get an undue hardship, because they read undue hardship, I say, well, that's fine, we can try that, but you got to pay legal fees up front of $7,500, and of course nobody can do that. So a lot of these cases are not really well litigated, but the few that have been, there has been a little bit of movement on the part of judges to find a little bit more willingness to discharge the debt. In addition, and this is actually really important, when you have federal student loans, you have access to the loan forgiveness programs and the income-based repayment programs set up by the Department of Education. And these programs have been expanded over the past few years, where you've got some that let you pay based on your income. There's a formula that you plug into, and it's not going to force you to live like a pauper, but you can pay for 10 years. Sometimes it's as little as 10 years, which is still a long time, but 10 years and you can discharge the debt. Or you have some other situations where if you are a teacher or you work in public service, you can get the loans forgiven by going to the Public Service Loan Forgiveness Program or the Teachers Loan Forgiveness Program. So there is some hope for government loans, Department of Education loans, either through a loan forgiveness income-based repayment program or possibly through discharge under the undue hardship program. So I think if you've got federal loans, you've actually got some reasonable opportunity. Now, private loans are a different story, and that's going to be the subject of a different video, and that's where some big changes are happening, and I'm going to talk about those in another video. But just so you know, when people talk about the Brunner Test, that's what the Brunner Test is. It's spelled B-R-U-N-N-E-R if you want to look it up. But the Brunner Test is sort of the standard for what it means to discharge student loan debt. It's traditionally a very, very hard line standard, but again, if you look at it and you look at some of the cases in your jurisdiction, and you can go to the clerk of court and actually look at those cases, your lawyer can certainly research it. You may find that some judges might be a little more willing than they used to give you a little bit of a break on these student loan debts. And again, I think part of this is because I think there's a perception that maybe Brunner is too strict, and secondly because there's a public policy problem of too many people living in their mom's basement because of student loans they can't pay, and maybe some of the debtors, the young people that took out these loans are maybe not entirely at fault in taking out loans when the colleges are really doing very little to keep the cost of education low, and bankruptcy courts maybe see a little bit of a role to right that situation. So if you wanted to know what Brunner was and undue hardship, now you know. Hope you found this helpful. If you did find this video useful, please give it a thumbs up on YouTube, like it on Facebook, subscribe to my YouTube channel and my Facebook page. There'll be more coming out. And again, I will do another video about private student loans in the very near future. So this is Jonathan Ginsburg wishing you the best. Thanks a lot.
Hi, this is Jonathan, and I hope you found this video helpful. I'd like to invite you to download my free Debt Destroyer Survival Kit right now. I've packed my survival kit with answers to the questions I've heard from clients for over 25 years here in the Atlanta area. Inside the survival kit, you'll find clear, easy to understand answers to critical topics about how to solve debt problems once and for all, including how do I protect my stuff, my house, car, and personal property if I file for bankruptcy? Are there any legitimate alternatives to bankruptcy? Will I ever get credit again, and if so, when? What mistakes must I avoid to get the most benefit out of bankruptcy? You can claim your copy right now by visiting my atlanta-bankruptcy.com website. And you are always welcome to use the email form on my website to ask me anything about debt and personal bankruptcy in Atlanta. www.atlanta-bankruptcy.com. And as always, I wish you the best.